Hi, my name is Yogya Bhatia and I'm a legal intern at LEXIS and Company. Today I'll be talking about insanity as a defense under the Indian Penal Code. Insanity as a defense in Indian remains an unsolved problem in criminal jurisprudence. However, it presents some fascinating problems that deserve careful analysis. Therefore, there are few studies on the exploration of the clinical picture of patients in prison. In 2011, forensic psychiatry study in which 5,024 prisoners were evaluated in a semi-structured interview program that showed the analysis that 4,002 people could be diagnosed with disease diagnosis, mental or substance use. The philosophical basis for the exemption of crazy transgressors from criminal responsibility is perhaps the functional limitation of retributive and dissuasive theories of punishment that highlights the provision of Section 84 of the Indian Criminal Code that is based on MC Norton 1843 rule in England. Other research from India describes a very full damage, adult image of a patient in forensic psychiatry with the support of supporters of the need to rationalize the strategy of referral, diagnosis, and treatment and certification. There is a well-established principle, actus non facet reum nisi mens rea, which in literal sense means an act done does not make an offender liable without a guilty mind. The intention or guilty mind of the offender is an integral part while committing a crime. The defense of insanity is a law that protects a person who is incapable of understanding the nature of the act done by him. The unsoundness of mind should be of such an extent that it makes the offender completely incompetent in knowing the nature of the act. The fact that the person is suffering from a mental illness is by itself not sufficient to prove that he is insane. Under Indian law, the rationale of insanity is defense is incorporated in Section 84 of the Indian Penal Code and is based upon MC Norton's rule. The burden of proof is always on the defendant and it has to be proved beyond a reasonable doubt. The Law Commission of India in its 42nd report made an effort to reanalyze Section 84 but no modifications were made. Origins of the rules on the plea of insanity. The insanity law as a defense has been in existence from many centuries, but it took a legal status from the last three countries. The history of the law of insanity can be traced back to the 1700s. The first case that dealt with the law of insanity was R.V. Arnold, in which Edward Arnold attempted to kill and even wound Lord Onslow and was tried for the same. The evidence clearly showed that the accused was suffering from a mental disorder. If he was under the visitation of God and could not distinguish between good and evil and did not know what he did, though he committed the greatest offense, yet he could not be guilty of any offense against any law whatsoever. As stated in the aforementioned case, a person can demand immunity if due to his unsoundness of mind he was incapable of distinguishing between good and evil and did not know the nature of the act committed by him. This test is known as the wild beast test. The second test involved in Hatfield's case. Hatfield was discharged from an army on the ground of insanity and was tried for high treason in attempting to assassinate King George III. The counsel of the accused, Lord Thomas Exon, defending him and proved in front of the judge that Hatfield had only pretended to kill the king and is not guilty, on the ground of insane delusion from which the accused was suffering. Erickson stated that insanity was to be determined by the fact of fixed insane delusion and that such delusion under which defendant acted is the main reason for his crime. This test, known as the insane delusion test. Finally, the third test was formulated in Bowler's case. In this case, Lee Blanc Jr. stated that the jury has to decide when the accused committed the offense, whether he was capable of distinguishing right from wrong or under the control of an illusion. After the Boiler's case, the courts have placed more emphasis on the capacity of the accused to distinguish from right to wrong, though the test was not clear. MC Norton's rule. There have been several tests from time to time, like the wild beast test, insane delusion test, etc., but the most important is the right and wrong test formulated in M. Norton's case. The hearing of M. Norton and his release was a topic of discussion in House of Lords, and as consequence, they called upon 15 judges to decide on the question of criminal liability in the cases where the accused is incapable of understanding the nature of the act and also answer the question in advance. 14 judges had the same answers. The view of the majority was given by Tyndall CJ. These answers to the question are known as M. Norton's rule. The following principles were cited. If the person knew what he was doing or was only under a partial delusion, then he is punishable. There is an assumption that every man is prudent or sane and knows what he is doing and is responsible for the same. To establish a defense based on insanity, it must be ascertained at the time of the perpetrating the act, the accused was in such a state of mind as was unable to know the nature of the act committed by him. A person who has sufficient medical knowledge or is a medical man and is familiar with the disease of insanity cannot be asked to give his opinion because it is for the jury to determine and decide upon the questions. English law on the defense of insanity. English criminal law considers insanity a valid defense of crime. The fundamental definition of insanity is based on M. Norton's rule. These rules are not about insanity medical definitions. In M. Norton's case, the judges declared the following insanity principles. All are presumed to be the same and have enough reason. It must be clear demonstrated in order to establish the defense of insanity. He didn't know the nature and the qualities of the act he was doing, or he did not know what he was doing was wrong.